SwayamPrabha. Digital India. Educated India.
Hello friends, after making an elaborate discussion over two basic and fundamental rules of natural justice, in the present session I have come with the topic Judicial Review of Administrative Action. In earlier sessions we have seen that what is the concept, what is the meaning of natural justice, and what are two basic or fundamental rules of natural justice which are essential to be applicable in all the administrative decision making. The judicial review of administrative action is equally important. To apply or to ensure the application of principles of natural justice in administrative decision making process. From very earlier discussion, from very outset of our discussion over the course of administrative law, I have been telling you continuously that administrative law has been evolved to regulate the administrative activities for ensuring the constitutionalism in any system, for attaining the objective of rule of law. In this regime of modern welfare state, the administrative law has become the need for controlling or for limiting the powers of the administration. Judicial review of administrative action is one important principle whereby we keep the administration within its defined limits. It has been an objective of administrative law to provide for any such way outs, any such mechanism, any such ways by which the administration can be kept within the defined limits of powers. And it can be kept within the defined limits of powers only when we prescribe certain procedures to be followed, to be adopted by the administrative authorities in making the administrative and administrative adjudicatory decisions. At the same time, it is also important to check the administration continuously whether it is in accordance with those standards, whether the administration exceeds its powers which have been conferred on it, whether the administration follows the procedures which are essential for it to follow, whether the administration makes the rational decisions, whether there are any irregularities or illegalities in the administrative decision making, or whether the administration is making the decisions in accordance with the doctrine of proportionality and doctrine of legitimate expectation. The judicial review becomes the need. Under the doctrine of separation of powers also, we have discussed that the separation of powers can be applied only in the form of checks and balances. Without the effective system of checks and balances, all the three organs of the state cannot be kept within their bounds. And therefore, The judicial review of administrative action is also such a check over the authority, over the power of administration, wherein the judiciary reviews the decisions of the administration or administrative bodies or the administrative adjudicatory bodies on different grounds. For understanding the concept of judicial review of administrative action, we are to understand first the meaning of review and then the meaning of judicial review. Though the judicial review is made by the courts in different ways, like the judicial review of legislative action, the judicial review of judicial action also, wherein the courts, the higher courts review the decisions of the inferior courts, and then the judicial review of administrative action. But as the student of administrative law, we are concerned with the judicial review of administrative action. If we try to understand the meaning of review, review as the noun refers to the examination or consideration of something again to determine if any changes are required. It means to look at something again, judging something again, reconsideration or reassessment of something or critical examination of something by any authority, by any body. Judicial review of administrative action refers to power of Supreme Court or high courts to examine the validity of any administrative action by any public authority. So, if any public authority takes any action, makes any decision, then the higher courts review that decision or that action being taken by the public authority, whether it is within the bounds of that authority or not. Judicial review assigns to the higher judiciary the role of interpreter and observer. In our country also, the higher judiciary has been assigned the function of the interpreter of law, the interpreter of the constitution itself, and also the observer to observe whether the other two organs of the state, organs of the government are acting in accordance with the standards of the constitution or not. The Supreme Court is considered to be the protector of fundamental rights, fundamental freedoms, and the basic liberties of the citizens of the country. Our Supreme Court also acts as the final interpreter of law and the constitution. In this regard, the Supreme Court takes the superior most position in matters of the judicial review of administrative action, judicial review of legislative action, and also the judicial review of judicial action. And hence, the Supreme Court has declared the judicial review as the basic structure of Indian Constitution. From very beginning of the concept of basic structure of Indian Constitution, when it was evolved by the Supreme Court of India in the case of Keswanand Bharati, to put the limitations over the authority of, over the unlimited power of the Parliament to amend the Constitution under Article 368. From that very case, the Keswanand Bharati, the judicial review has been recognized, considered and declared by the Supreme Court of India in number of cases are the essential part of the basic structure of Indian Constitution. The judicial review is a constitutional doctrine which grants to the higher judiciary the power to examine the constitutionality of any legislative or executive action of the government on the basis of constitutional parameters, on the basis of constitutional standards, on the ground of legal standards. If the courts find such action inconsistent with the constitutional and legal standards, it declares these actions as null, void and inoperative, ultra vires, invalid. The judicial review refers to a procedure that permits the higher judiciary to review the validity of legislative and executive acts and to annul these acts if it finds these acts unconstitutional. Now see the judicial review by the Supreme Court. As we all know that in India, the Supreme Court is the apex Indian court. It is the superior most court of appeal and superior most court for the purpose of such review. The Supreme Court of India is the highest court of appeal in all the civil matters, in all the criminal matters and even in all the constitutional matters. The Supreme Court of India is the ultimate protector of fundamental rights of the people of India. The Supreme Court of India is the concluding interpreter of the constitutional principles and the constitutional provisions. And therefore, the judicial review is the soul of any democratic system, because without the power of judicial review in the hands of the higher courts, the democracy and the rule of law cannot be maintained. The democracy and the rule of law cannot survive. It was held by the Supreme Court of India in the case of Minerva Mills versus Union of India, decided in 1980, wherein the Supreme Court declares the concept of judicial review as the soul of the democratic system, as the soul of our constitution also. And therefore, in Minerva Mills case also, the judicial review was considered to be the essential element of the doctrine of basic structure of Indian constitution. The judicial review is the way out by which the democratic pattern, the rule of law can prevail in the country. If you see the judicial review by the Supreme Court of India, it seems that the Supreme Court has been endowed with the power of judicial review under Article 32 of the Constitution of India. Article 13, Article 36 also gives the power to the Supreme Court to review any legislative action on the ground of violation of fundamental rights. Article 13 gives this authority to the Supreme Court to review any legislative action, either this action is being taken by the executive or the legislature on the ground of fundamental rights. Article 36 gives the special power to the Supreme Court of India to grant the leave for appeal directly to the Supreme Court. This is very broad power given to the Supreme Court of India under Article 36 for the purpose of the review by the Supreme Court of the decisions being taken by the judicial authorities. In Article 32, the Supreme Court of India has been given the power to deal directly with the cases of violation of fundamental rights. Article 32 is considered to be the remedy for the enforcement of rights conferred by Part 3, that is the fundamental rights of the people in India. Article 32 is also the part of fundamental rights. It is the fundamental right to enforce the fundamental rights. Article 32 is itself a fundamental right wherein the citizens are entitled to enforce their fundamental rights against the state. See Article 32. Article 32 clause 1 states that the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by Part 3, this part is guaranteed. So, the clause 1 of Article 32 guarantees the fundamental right to enforce the rights conferred by the Constitution under Part 3. The clause 2 of Article 32 provides for the remedies, provides for the ways for the guarantee of the enforcement of fundamental rights. The clause 2 of Article 32 states that the Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. So, under clause 2 of Article 32, the Supreme Court of India is empowered to issue any direction, any order or any writs, including all the 5 writs, which it finds appropriate for the enforcement of fundamental rights in a particular case. The right guaranteed by Article 32 cannot be suspended except as otherwise provided for by this Constitution. It is also provided within Article 32 itself that no authority in India can suspend Article 32 or the right guaranteed under Article 32 except otherwise provided for this Constitution. It can be suspended only in accordance with the provisions of Indian Constitution and not otherwise. The right to move to the Supreme Court for enforcing fundamental rights is itself a fundamental right, and the court has no discretion to refuse to grant an appropriate remedy if the violation of any fundamental right is established. The Supreme Court of India itself, in the case of Fertilizer Corporation Kamgar Union versus Union of India in 1981, held so, wherein the Supreme Court was of the opinion that the right to move to the Supreme Court for enforcing fundamental right is itself a fundamental right, and the court has no discretion to refuse to grant an appropriate remedy if the violation of fundamental right is established. It means once the violation of fundamental rights is established, that this is not the discretion of the court has to give the remedy. It means that it is not only discretion, it is not only power, it is not only right, it is not only jurisdiction of the Supreme Court under Article 32, but it is an obligation of the Supreme Court of India, it is a responsibility of the Supreme Court of India which has been imposed by the makers of the Constitution through Article 32 on the Supreme Court to protect and safeguard the fundamental rights of the people and to provide appropriate remedies in cases of violation of fundamental rights. And this essence of Article 32 makes the Supreme Court of India as the final protector of the fundamental rights of the people. Article 13 of the Constitution of India also gives the power to the Supreme Court and to High Courts also to declare any such law as void which is found inconsistent with the fundamental rights. The clause 1 of Article 13 lays down that all the laws in force in the territory of India immediately before the commencement of this Constitution, meaning thereby it talks about the existing laws which were operative at the time of commencement of Indian Constitution and which were not repealed. Insofar they are inconsistent with the provisions of this part, shall to the extent of such inconsistency be void. So, both the laws, either these are existing laws or these are the present laws being enacted by the legislature, if these are found inconsistent with the fundamental rights, shall be void to the extent of their inconsistency with fundamental rights. If you see the meaning of the term law which has been given in Article 32 Clause 3, it includes both the legislation and delegated legislation. Delegated legislation means the legislation being enacted by the executive under the power delegated to it, which we have already discussed under the topic of delegated legislation and its various aspects. Article 13 Clause 3 states that in this article, unless the context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, custom or uses having in the territory of India the force of law. Laws in force includes laws passed or made by legislature or other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be then in operation either at all or in particular areas. So, the meaning of the law under clause 3 of article 13 refers to all kind of laws being enacted either by legislature or by the executive. So, the administrative action or the rule making by the administration is also within the scope of the meaning of law under article 13. Article 136 of our constitution gives the special power to the Supreme Court to grant special leave to appeal by the Supreme Court of India. Though the hierarchy of the courts has been established and the appeal can be made in accordance with that hierarchy, the appeal can be initiated to the Supreme Court only against the decisions of the competent High Court, and the provisions have also laid down regarding the appeal that only after the certificate being issued by, there are very rare subject matters in which without the issue of certificate of the High Court, the Supreme Court will entertain the appeal. But in article 136, the Supreme Court is given the authority to grant the special leave for appeal to the Supreme Court in any case, even against the decision of a judge of subordinate judiciary, even against the decision of a magistrate, the Supreme Court can hear the appeal if it finds it appropriate. So, article 136 is also very important with regard to the judicial power of judicial review of the Supreme Court. This article 136 also refers to the tribunals. It means that administrative adjudicatory bodies are also the scope within the ambit of article 136, because the tribunal refers to a statutory authority exercising the power to affect the rights of the people. If we try to find out the status of the judicial review by the high courts, we can refer to article 226 and article 227 of Indian Constitution. Article 226 gives the power to the high courts to issue certain writs. Clause 1 of article 226 states, notwithstanding anything in article 32, every high court shall have the power throughout the territory in relation to which it exercises jurisdiction to issue to any person or any authority, including in appropriate cases any government within those territories, directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, or any of them for the enforcement of any of the rights conferred by part 3 and for any other purpose. This phrase, conferred by part 3 and for any other purpose, gives the wider jurisdiction to the high courts as compared to the jurisdiction of the Supreme Court of India in article 32. Under article 32, the Supreme Court can issue these directions, these orders or these writs only on the instance of the violation of fundamental rights. it can issue these writs and directions only for the purpose of protection of fundamental rights. But the High Court can issue these directions, orders and writs for the violation of fundamental rights as well for the violation of any other right or for the any other purpose. Clause 2 of Article 226 states that the power conferred by Clause 1 to issue directions, orders or writs to any government, authority or person may also be exercised by any High Court exercising jurisdiction in relation to the territories within which the cause of action wholly or in part arises for the exercise of such power, notwithstanding that the seat of such government or authority or the residence of such person is not within those territories. Clause 3 states that where any party against whom an interim order, whether by way of injunction or stay or in any other manner, is made on or in any proceedings relating to a petition under Clause 1 without furnishing to such party copies of such petition and all documents in support of the plea for such interim order. So, within the proceedings of the High Court also, the principles of natural justice, the rule of hearing or the right to know the evidence has been recognized. Giving such party an opportunity of being heard makes an application to the High Court for the vacation of such order and furnishes a copy of such application to the party in whose favor such order has been made or the counsel of such party. The High Court shall dispose of the application within a period of 2 weeks from the date on which it is received or from the date on which the copy of such application is so furnished, whichever is later, or where the High Court is closed on the last day of that period before the expiry of the next day afterwards on which the High Court is open, and if the application is not so disposed of, the interim order shall on the expiry of that period or as the case may be, the expiry of that next day stand vacated. So, the time limit has also been fixed. Clause 4 states that the power conferred on a High Court by this article shall not be in derogation of the power conferred on the Supreme Court by Clause 2 of Article 32. So, there may not be any clash in the High Courts in the Supreme Court of India. The Clause 4 has been included in Article 226. So, Article 226 is also very important provision of our Constitution with reference to the power of judicial review of the High Court, wherein the High Courts are given the authority, High Courts are given the power to issue any order, any direction or any writ in the form of the writ of habeas corpus, writ of certiorari, writ of mandamus, writ of quo warranto or writ of prohibition. Article 227 is also relevant with the power of High Court to make the judicial review. Article 227 relates to the power of superintendence of the High Court over all courts, wherein it is provided that every High Court shall have superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. Without prejudice to the generality of the foregoing provisions, the High Court may call for returns from such courts, make and issue general rules and prescribe forms for regulating the practice and proceedings of such courts. C. Prescribes forms in which books, entries and accounts shall be kept by the officers of such court. And Clause 3 of 227 states that the High Court may also settle tables of fees to be allowed to the sheriff and all clerks and officers of such courts and to attorneys, advocates and pleaders practicing therein, provided that any rule made, forms prescribed or tables settled under Clause 2 or Clause 3 shall not be inconsistent with the provisions of any law for the time being in force and shall require the previous approval of the governor. So, again you can see the concept of the principle of checks and balances involved in these provisions. The High Court is given the power of superintendence over all the courts and tribunals. This is the authority of High Court to review the decisions of all the courts and tribunals, and at the same time the check has also been imposed over the authority of High Court, that the High Court can make such provisions only after the approval of the governor. Clause 4 of Article 227 states, nothing in this article shall be deemed to confer on a High Court powers of superintendence over any court or tribunals constituted by or under any law relating to the armed forces. So, it is not given the authority over the armed forces. Courts of the courts or adjudicatory bodies of armed forces. Now, the question arises that under Article 32, under Article 226, what are the authorities or the authorities which are amenable to the judicial review under Article 32, under Article 226, meaning thereby against which authorities the Supreme Court can issue the directions, the orders or the writs under Article 32, and against which authorities the High Courts can issue the writs, orders or directions. We know that Article 32, it is confined only for the enforcement of fundamental rights, and the fundamental rights are available, are recognized, are enforced against the state. There are some fundamental rights like the fundamental right recognized by Article 15 clause 2, the fundamental right recognized by Article 17, the fundamental right recognized by Article 23 clause 1 and Article 24. Only these fundamental rights can be claimed also against the private individuals. Otherwise, all the fundamental rights are recognized, all the fundamental rights are enforced against the state. So, it is clear that when the power has been conferred on the Supreme Court under Article 32 to issue the orders, directions or the writs for the protection of fundamental rights, for the enforcement of fundamental rights, or to preserve the fundamental rights against any kind of violations on the part of the government, then it means that only the authorities which come within the ambit or the scope of the meaning of state are amenable to the judicial review by the Supreme Court under Article 32. What are the authorities which come within the ambit or scope of the meaning of term state has been defined in Article 12, and the courts have also, the Supreme Court of India has also made the interpretation of the term other authorities under Article 12 to include more and more authorities within the meaning of the term state. So, only those authorities which come within the meaning of state amenable to the judicial review by the Supreme Court under Article 32, then the relevant question arises whether private individuals and courts are amenable to the judicial review by the Supreme Court under Article 32. The answer is that because the fundamental rights are available against the state, they are enforced against the state, then only the authorities coming within the meaning of term state under Article 12 are amenable to the judicial review, not the private persons. Then the question arises, how to protect the fundamental rights against any violations by private individuals. Different mechanism has been provided, has been evolved, wherein the parliament, by making the law, prescribes the punishments for the violations of such fundamental rights. For example, in the area of social justice, we know untouchability right against untouchability has been recognized by our constitution as a fundamental right, and it can be violated by private individuals also. So, the law against any such kind of incidences of untouchability has been enacted by Indian Parliament. High courts have a wider power than Supreme Court of India. I have already pointed out by observing, by analyzing the phraseology adopted by the makers of our constitution in Article 32 and 226, because the high courts can issue writs against any person or authority, not only against the state, because it is for all other purposes also. For the enforcement of fundamental rights and for the enforcement of any other legal right, the directions etc. can be issued by the High Court, and therefore the High Court exercises the broader power as compared to the Supreme Court of India under Article 32. After understanding the position of the Supreme Court of India and the position of the different high courts in relation to the power of judicial review, that how the Supreme Court of India and the high courts are made competent, are empowered to make the judicial review over administrative action, we are to know the grounds of judicial review, that on what grounds the Supreme Court of India and the high courts can interfere in any administrative decision, in any administrative proceedings or in any administrative action. What are the grounds of judicial review? Friends, the grounds of judicial review cannot be exhaustive. A precise list of the grounds of judicial review cannot be made, but there are some recognized grounds of judicial review which have been recognized, which have been established by the English courts and Indian courts during the course of their functioning. These are illegality, irrationality, procedural impropriety, doctrine of proportionality, and denial of legitimate expectation. What is illegality as the ground of judicial review? The ground illegality to review any administrative action is based on the principle that every administrative authority must know its limits of power under the law before taking any action. The ground of illegality gives rise to the different grounds of judicial review of any administrative action, like the lack of jurisdiction, the access of jurisdiction, the abuse of jurisdiction, the failure to exercise jurisdiction. These are the different grounds which come out, which emanates from the ground of illegality. Lack of jurisdiction. It is the ground of judicial review if the authority did not have jurisdiction but took the action. That may happen when the authority itself is constituted improperly. The law which gives the power to the authority to take the action itself illegal, invalid. Then there is the ground of lack of jurisdiction. But if the authority has the jurisdiction, it is established, it is created properly, but when it exceeds the limits of its jurisdiction in taking the action, then this is the ground of excess of jurisdiction. Abuse of jurisdiction refers to the situation where the authority has the jurisdiction, it does not exceed the jurisdiction, but it does not take into consideration any essential consideration which should have been the base of or basis of the decision, or it takes into consideration some extraneous consideration which should have not been taken into consideration. This is the situation of abuse of jurisdiction. Failure of jurisdiction, where the authority had the jurisdiction, but it failed to exercise its jurisdiction. It is also the ground of judicial review. Second one is irrationality. The irrationality refers to Wednesbury principle, because the ground of irrationality was evolved in the case of Wednesbury. Wednesbury principle refers to reasonableness. Any decision becomes unreasonable as per Wednesbury principle if it is based on wholly irrelevant material or irrelevant considerations. If it ignores an important and relevant material or consideration, if it is so strange, incongruous and illogical that no reasonable person could arrive at such a conclusion in given facts and circumstances. If these situations exist, it refers to the ground of irrationality, or it is the Wednesbury principle on the ground of which the judicial review is exercised by the courts. When the decision is based on wholly irrelevant material or irrelevant considerations, when the authority ignores an important and relevant material or consideration, or the decision is so strange that no reasonable person could reach to such a conclusion in a given circumstance, this becomes the ground of irrationality. Procedural impropriety is also the ground of judicial review. Procedural impropriety refers to the violation, disregard and omission of any prescribed procedure by the administrative authority. If any procedure is prescribed and the authority omits, disregards or violates that procedure in making the decision, in taking the action, then there is the ground of procedural impropriety. If any procedure has been prescribed by the statute, the administrative authority is mandatorily obliged to follow, to adopt that procedure. Any violation or disregard to such prescribed procedure would vitiate an administrative proceedings and it would become the ground of judicial review. If the relevant statute is silent, then the courts have been insisting that at least minimum fair procedure must be followed by the authority in taking the decision. The minimum fair procedures we know refers to the principles of natural justice. So, if the statute is silent on the procedure, then the minimum fair procedure should be adopted. So, the doctrine of proportionality is a new ground of judicial review. It has emerged as a new ground of judicial review of administrative discretion. When the administration or administrative authority enjoys, exercises any discretion, then the doctrine of proportionality may be taken as the ground of review of that exercise of discretion. The doctrine of proportionality is aimed at maintaining proper balance between the adverse effect of any action taken or the decision made on the rights, liberties or interest of a person and the purpose of the action taken or decision made. So, the doctrine of proportionality has been evolved for maintaining the proper balance between the adverse effect of any action taken by the administrative authority and on the liberties or interest of the person and the purpose of the action taken or the decision made. There are two important aspects of any administrative decision. Number one, the manner or the procedure or the way out being adopted by the administrative authority in taking the action, and number two, the objective or the purpose of that action. So, it is to be seen under the ground of proportionality that what is the consequences, what are the consequences, what is the effect of the decision made or the action taken by the administrative authority on the rights, liberties and freedoms of individual, and on the other hand the objective of that decision, with what an objective that decision was made or the action was taken. So, it is to create the proper balance between these two opposite ends. The effect, the consequences on the liberties, freedoms, rights of the people of the decision taken and the objective of that decision. There must be the reasonable proportion in these two. The doctrine of proportionality confines the exercise of discretionary powers of administrative authorities only proportionate to the objective sought by exercise of such discretionary powers. So, the decision being taken by the administrative authorities or the exercise of the discretion by the administrative authorities must always be in the proportion. The decision taken by the authority must always be in the proportion to the objective being sought by taking that decision. By applying this doctrine of proportionality, the court can quash the decision of an administrative authority if it does not find any reasonable balance or the proportion in the objective sought to be achieved and the means used. So, as I told you that the doctrine of proportionality, the ground of judicial review in the name of doctrine of proportionality, was evolved to create the balance between the means to be taken by the administrative bodies in taking the decisions and the objective of those decisions, and therefore, if the court finds that there is no reasonable balance in the proportion or there is no reasonable proportion in the objective sought and the means used, then it can quash the decision or it can review the decision on the ground of proportionality. We can refer to the case of Union of India versus Kuldeep Singh to understand the real objective of doctrine of proportionality and how the doctrine of proportionality is taken as a ground of judicial review. In the case of Union of India versus Kuldeep Singh, the penalty imposed, it was held by the Supreme Court of India that the penalty imposed must be in proportion to the gravity of misconduct. And the Supreme Court was of the view that if any penalty is found to be disproportionate to the misconduct, that would be violative of Article 14 of Indian Constitution. Because Indian Constitution, Article 14 of Indian Constitution, the equality clause, it bars the administrative bodies to take any arbitrary action. And therefore, in accordance with the doctrine of proportionality, it is important or it is even mandatory for any administrative body to take the decision or to impose the penalty only in reasonable proportional to the gravity of misconduct. If the penalty imposed is found disproportionate to the gravity of disproportionate to the misconduct done by the person concerned, then it would be violative of Article 14 of Indian Constitution and the ground of proportionality would become the ground of judicial review for this purpose. In the case of Ranjit Thakur versus Union of India, which was decided by the Supreme Court in 1987, an army officer did not follow the lawful command of his senior officer by not eating the food offered to him. Some food was offered to him to eat, but he did not eat the food offered to him. And this command of senior officer was not followed by that officer. The court martial was made, and in court martial proceedings, the punishment of rigorous imprisonment of 1 year was awarded. Not only this, he was also dismissed from the service. So, for not following the command of senior officer to eat a particular food, that army officer was dismissed from the service, number one, and he was awarded rigorous imprisonment of 1 year. He was also declared unfit for future employment. You can understand that the penalty imposed or the punishment given to that army officer cannot be considered to be reasonable or in reasonable proportional to the misconduct made or the misconduct done by that army officer. And therefore, the Supreme Court of India in Ranjit Thakur versus Union of India quash the decision on the ground that it was grossly disproportionate to the misconduct made by the army officer. Doctrine of legitimate expectation is another ground of judicial review. This doctrine was evolved to give relief to the people in circumstances where they are not able to justify their claims on the basis of law, pure and simple, even after suffering civil consequences because of violation of their legitimate expectation. There may be some cases where any person may suffer civil consequences not for the violation of law, but for the violation of the legitimate expectation. So, if their claim is not based on any law simple and pure, but their claim is based on only the legitimate expectation, they can get the remedy. For this purpose, the doctrine of legitimate expectation was evolved. First, it was propounded by Lord Denning in England in 1969, and thereafter it has been recognized as public law doctrine in almost all the jurisdictions of democratic world. In India also, this public law ground of judicial review was developed by the courts to check the arbitrary exercise of power by administrative authorities. In accordance with the approach of private law, a person has locus standi to move to the court when his right recognized by any statute or contract has been violated. So, if any right recognized by any law or any contract is violated, only then the person has the locus standi in private law, but not for denial of legitimate expectation in the absence of any such recognized right. If any such recognized right is absent, then that person cannot claim on the basis of the ancient doctrine or ancient principle, ibi jus ubi remedium. But under the present doctrine, this rule of locus standi is relaxed in the area of public law to allow a person to move to the court when a public authority denies or violates any legitimate expectation from it. The legitimate expectation may arise from such a statement or promise made by any administrative authority or even a well recognized and established past practice which cannot be violated without good reasons. This was held by the House of Lords in Council of Civil Services Union versus Minister of Civil Services. In the case of Chimit, Secretary of State for Home Affairs, the government shortened the period already allowed to a non-native foreigner to stay in England. It was held that the person had a legitimate expectation to stay in England for such a period. It could be altered only by a fair and reasonable procedure. It seems that Lord Denning used the term legitimate expectation first time in place of the term right. So, in India also, the doctrine of legitimate expectation has been recognized by our apex court under its authority to import legal doctrines and principles to apply them in Indian judicial procedure. Indian courts have established that the doctrine confers an enforceable right on a person in case of denial of his legitimate expectation. Whether an expectation is legitimate or not is question of fact, and it cannot be ascertained on the basis of claimant's perception, but has to be determined on the consideration of larger public interest. So, in India, the doctrine of legitimate expectation has also been recognized as a sound ground for reviewing the decision of administrative bodies. It has been recognized as a valid ground of judicial review. In the present lecture, we discussed the grounds of the judicial review. What are the modes of judicial review by which the courts exercise the power of judicial review, through which the courts exercise the power of judicial review, we will discuss in the next lecture. Thank you.
Hello, good morning everybody. I am Raghunandan Sengupta. So, I will just give you a very brief excitement area of finance, which is quantitative finance, and that has a huge market starting around about 10 years back, and it is exploding exponentially. So, what do we mean by quantitative finance? Quantitative finance is actually the application of different mathematical and statistical techniques in the area of financial markets, be it say for example derivative pricing, be it in the area of say for example portfolio management, be it in the area of asset liability management, be it in the area of portfolio management. We see that the application has exploded in such a way that there is a huge opportunity for people who have a quantitative background in mathematics and statistics. They can utilize those in the area of finance, but obviously with some prior knowledge of finance as a subject. Now, when we say about quantitative finance, as I said, it is an area of applied mathematics and statistics applied in financial markets. Use of different areas, if somebody is interested to know, we have stochastic calculus, we have derivative pricing, we have operation research, we have quantitative techniques like differential equations, stochastic calculus, time series, and they are heavily used in the area of quantitative finance as I mentioned. Now, we all know that in 1997 the Nobel Prize in Economics, so it is basically the Nobel Memorial Prize in Economics was given to the work of Merton and Scholz in the area of derivative pricing, and after that there has been exponential increase in the area of quantitative techniques in quantitative finance and in the area of different type of derivative pricing. With the advent, moreover with the advent of high-ended and sophisticated computing data, big data has come in a very big way, where application areas starting from computing, from different type of algorithm design have been taken up in such a big way that nowadays at least we are able to understand that how high frequency data algorithm trading can be utilized using the concept of quantitative finance in the area of finance as such. But there is a flip side also, obviously when there is a huge amount of development. So, obviously due to some regulation errors or something, there has been some pitfalls, which I think is should be a bullet point for people who are really interested to take up quantitative finance, they should be aware. So, consider the financial crisis in 2008 and later on, and we are seeing different banks are failing, different financial institutions are facing a problem, countries are facing a problem like in Europe, in USA. So, what should be done? So, the main thing is that even if you know the technique is best for people who are investors, who are private players, organizations like banks, governments should use these techniques in a very somber manner, such that the application areas of quantitative finance using the techniques which we learned can be utilized in the best possible way to garner the overall the in-depth knowledge a person has in trying to utilize these quantitative techniques in finance. And I am sure that people who have the background, who have the knowledge, who have the sophistication, who have the knowledge of the society can definitely use quantitative finance in a very big way in trying to make their mark in this exciting field, which you are going to see in years to come. And I am sure it will be a very exciting learning tool for all the participants who will take quantitative finance as a subject in years to come. Thank you, and I wish all the participants all the best and best of luck for the programs they will take. Thank you.